Look, if you're building a legitimate business, you're inevitably going to collide with intellectual property. It's kind of like a double-edged sword. On one hand, it's absolutely the greatest fortress you can build to protect your brand, your product, and your ideas. But on the other, it's a dangerous legal minefield with rules you can easily trip over without even meaning to. So today, we're going to explore exactly how to protect your own work and, honestly, just as importantly, how to avoid accidentally stepping on someone else's.
Now, before we jump in, a quick note. This explanator provides an educational overview of intellectual property case studies for future business leaders, and it should not be taken as legal advice. If you have any specific questions regarding trademark, patent, or copyright law, you really should consult with an attorney who has relevant expertise.
Okay, let's take a quick look at our roadmap. We'll kick things off by defining the IP minefield. Then we'll look at trademarks and brands, move right into copyrights and what I call the fair use trap, explore patents and biotech, and finally wrap up with some really actionable steps for protecting what you build.
Section 1. The Intellectual Property Minefield. Let's define the tools and the traps. All right, let's map out the playing field really quickly so you have a mental model of the 4 distinct types of intellectual property we're dealing with. First up, trademarks. These protect your brand identifiers. Think the iconic Nike swoosh. Next, copyrights. These protect original creative works like music or art. Then we have patents, which protect actual physical inventions, like a new machine or a specific scientific process. And finally, trade secrets. These protect highly valuable, secret information that gives you a competitive edge. The most famous example, the Coca-Cola formula, which is protected through extremely strict confidentiality, not public registration.
Section 2, Trademarks, Brands and Boundaries. Let's talk about avoiding consumer confusion.
The entire job of a trademark is to prevent customer confusion. Whether we're talking about a brand name, a logo, or even specific packaging, the core legal test for trademark infringement always comes down to this one single question. Would an ordinary consumer likely be confused about where a product actually comes from or who endorsed it?
Let me give you a wild example. VIP Products decided to use a highly famous whiskey brand's exact look to sell a squeaky dog toy parody. You've got Jack Daniel's iconic Old No. 7 brand bottle at 40% alcohol by volume pitted against a dog toy labeled Bad Spaniels, touting the Old No. 2 on your Tennessee carpet and 43% poo by vol. I mean, it's clearly a joke, right? Well, Jack Daniel's definitely didn't think so, and they sued.
This case actually went all the way to the Supreme Court in 2023. Justice Elena Kagan pointed out, this case is about dog toys and whiskey, 2 items seldom appearing in the same sentence. But here is the kicker. The unanimous Supreme Court ruling was a massive lesson for entrepreneurs everywhere. Humor or parody? It is not an automatic shield if you're using someone else's mark as a source identifier for your own goods. You literally can't just say, hey, it's a joke, to short-circuit trademark law if customers might actually think the famous brand endorsed your product.
Now, this beautifully illustrates a crucial contrast in trademark law. While Jack Daniel's could successfully defend its brand identity against a parody, the beauty brand Sol de Janeiro faced a totally different reality. They threatened to sue over a dupe product, Costco's Nutrius Brazilian Body Butter Cream, which happened to use the exact same jar shape as Sol de Janeiro's famous Bum Bum Cream. But a federal court handed Sol de Janeiro a loss. Why? Because functional packaging product, like a standard round jar, serves a useful purpose and isn't legally protectable as exclusive trade dress. Basically, you can't own standard functional features.
Section 3, Copyrights. Welcome to the fair use trap, where transformation just isn't enough.
This catches so many entrepreneurs by surprise. The crucial point here is that just changing a copyrighted work isn't a free pass. People constantly think, oh, if I just add my own spin to this image or sample, it's fair use. No, that is not the law. When deciding if an unlicensed use is actually fair, courts weigh 4 very specific factors: the purpose and character of the use, the nature of the original work, how much of it you actually took, and, crucially, the effect on the market for the original work.
Let's look at 2 Supreme Court cases that really draw the line here. In one instance, the rap group 2 Live Crew completely won their case for a genuine parody of Roy Orbison's Oh Pretty Woman. The court held this was a true parody because it specifically targeted and commented on the original song. On the flip side, the Andy Warhol Foundation lost a 7-2 Supreme Court decision back in 2023. Warhol had made silk screens from a copyrighted photo of the musician Prince taken by photographer Lynn Goldsmith. The court ruled against the foundation because their commercial use of the artwork served the exact same basic purpose as the original photograph, directly overlapping with the photographer's commercial market.
And the ultimate proof of that market overlap, it comes down to a very specific number: $10,000.
That is the exact fee Vanity Fair paid to the Andy Warhol Foundation to license the orange Prince image for a magazine cover commemorating Prince. That transaction entirely bypassed Lynn Goldsmith, the original photographer. So the court decided that a famous artist's stylistic flourish just isn't enough to claim fair use when the purpose and commercial use compete directly with the original creator's market.
Section 4. Patents, Biotech, and Ethics, the heavy human cost of invention.
Okay, let's pivot to patents. A patent is essentially a deal you make with the government. It rewards inventors with a temporary monopoly in exchange for publicly disclosing exactly how their new and useful machines, processes, or compositions actually work. Now, while patents can definitely be expensive and slow for small founders to get, they are incredibly powerful for protecting true inventions, simply because they prevent anyone else from making or selling your invention for a set number of years.
And the scope of what you can patent is absolutely massive. In the milestone 1980 Supreme Court case, Diamond versus Chakrabarty, a microbiologist actually invented a human-made genetically engineered bacterium capable of breaking down crude oil. This was something that literally did not exist in nature. The court ruled that this live microorganism was in fact patentable, citing 1952 Congressional Committee reports that patentable subject matter includes, quote, anything under the sun that is made by man. That single decision became the foundation for the entire modern biotech industry.
But we also have to acknowledge that the biotech industry's history involves profound human costs. Back in 1951, doctors took cervical cancer cells from Henrietta Lacks, a black mother of 5, completely without her knowledge. These cells became the very first immortalized human cell line, known today as HeLa cells, and they drove massive medical profits and innovations, including the polio vaccine. Now, while that 1980 Chakrabarty case established the modern standard for patenting human-made life, the cells taken from Lacks were utilized for decades without a single cent of compensation to her family. It was actually only very recently, in 2023 and 2024, that pharmaceutical giants like Novartis and Thermo Fisher reached settlements with the Lacks estate over lawsuits alleging they unjustly profited from commercializing her cells.
Section 5. Protecting what you build. Actionable steps for your venture.
All right, here is your actionable playbook as an entrepreneur. Step 1. Search and register your brand name and logo way before you start sinking money into printing signs or packaging. Step 2. Always clear your samples and image licenses before selling. Do not just assume a simple change shields you under fair use. Step 3. Secure your trade secrets with NDAs, and whatever you do, never misappropriate information from former employers. And finally, Step 4. Maintain meticulous records of your creation dates, registrations, and licenses. I promise you, a good paper trail is a professional's absolute best friend.
Real operators protect their own ideas, and they respect the boundaries of others. It definitely takes vigilance, but it is exactly how you build a lasting venture. So I'm going to leave you with this to consider. As you launch your next big idea, will your intellectual property be your strongest business fortress or your most expensive legal mistake?